Welcome to the Norman Report. This is Jeff Norman, and my guest today is Brad Smith. He is the former commissioner, the former chairman of the Federal Election Commission, not just a commissioner, but for a period of time was the chairman. He's currently a professor at, Capital University. He also is the chairman of the Center for Competitive Politics. Welcome, Brad. How are you today?
Thanks. I'm fine. I've got this blab figured out. This is the first time I've used it. It looks like a great new platform. I like it.
Yeah, I think it's going to be huge, as one of the presidential candidates would say. We had this in the works before Justice Scalia died. But since he did die, I think that might be an appropriate place to start our discussion. And I'm not asking for, an exhaustive take on his whole career, but maybe if we could focus on the issue of political speech, and particularly Justice Scalia's concurring opinion in Citizens United versus FEC. Your organization was the defendant in that.
The FEC, yeah, although I was not at the FEC at that time.
And it's not a personal thing anyway, but that is the name. People always say Citizens United, but it's just shorthand. The case was Citizens United versus FEC. Right. And so Justice Scalia wrote a concurring opinion in that. If you could just say a few words about him in general and as it relates to that opinion.
Sure. Justice Scalia was a very strong voice on the court in favor of free speech generally. And a lot of people don't realize this, but I mean, he voted to strike down laws that prohibited flag burning and a number of other areas that generally would sort of please liberals who might think they don't agree with Scalia on a lot of things. And in the area of campaign finance, he was a very strong opponent of most campaign finance laws. He wrote a concurrence in Citizens United, but his best opinions were probably a couple of dissents. One he wrote in McConnell versus Federal Election Commission, which is the case that upheld the constitutionality of the McCain-Feingold law about 15 years ago now, 12 years ago. And the other was his dissent in a case called Austin versus Michigan Chamber of Commerce, which is way back in 1990, in which he begins the dissent by saying, attention citizens of Michigan. And I'm having to paraphrase this. I don't have it in front of me, but he says, attention citizens of Michigan, your government has decided that you should not hear speeches or information from the following people. And he kind of goes through the groups that were limited there. And Austin versus Michigan Chamber of Commerce was one of the cases that, in fact, was overruled in Citizens United. It was a case in which the state of Michigan had a statute that prohibited corporations from spending any money in connection with elections.
Yeah, I'm glad you mentioned the flag burning case because one of the difficulties that those of us who agree with the court on Citizens United face is this widely held perception that the opinion was a product of right-wing reasoning. And in fact, the ACLU, Eliot Spitzer, Glenn Greenwald, and a number of other very reputable liberals think the court decided it correctly. And they think Scalia and the majority justices are the enemy, and maybe they are in other cases, but we don't have to get into that. Let's just focus on the Citizens United case. And this flag burning thing, the guy that is their big hero who wrote the 90-page dissent in Citizens United, Justice Stevens, he voted against protecting flag burning as protected speech. Did he not?
I believe he did, although
he did.
Memory. Yeah, it's one thing that people often overlook is that until recently, these issues were not generally left-right issues of campaign finance in the way they are now. For example, William O. Douglas, a great liberal lion on the Supreme Court, was very, very critical of campaign finance laws and emphasized that it was very important. I think he used the term vitally important that the people be able to hear from all points of views from all people. He said, unions, groups of citizens, trade associations, businesses. He said people need to hear all those voices. Chief Justice Earl Warren was joined Douglas in that very opinion that I was just referencing. And that's from a case called United Auto Workers versus United States. in which the government was going after the auto workers. And that's another thing that's worth noting, that these laws reach people all across the political spectrum. They reach unions, they reach liberal groups, they reach conservative groups, business associations. And historically, a lot of the court's, greatest liberal thinkers in the post-World War II era were very hostile to campaign finance reform. This sort of monolithic bloc idea that liberals will vote to uphold campaign finance reform is a relatively recent development.
Yeah, so just to follow up on what you said about who this reasoning applied to and who the opposite reasoning applied to, one of my favorite quotes from Scalia's concurring opinion is, where is it? Surely the dissent does not believe that speech by the Republican Party can be censored because it is not the speech of an individual American. You might have said, and the Democratic Party too. But right, I mean, isn't that where the logic would take you if you disagree with the court? Those are corporations, those parties, are they not?
Right, you're right. I think that's right. I mean, I think one thing people overlook is that, in fact, corporations do consist of people. People get together and they make up corporations. And the odd thing is that Citizens United wasn't based on this idea of corporate personhood. It doesn't come up anywhere in the opinion. It's a longstanding doctrine. It's based rather on the idea that you could limit people's speech simply because they were using a corporate form. And I think that's kind of silly. I mean, even if you believe that we should limit the amount that people can spend in campaigns, that we should, have some kinds of restrictions, I don't know why it makes sense to do this a blanket ban on corporations. I mean, if Exxon were to reorganize as a limited liability partnership with people who are concerned about Exxon's political power, suddenly go, oh, okay, their partnership, fine, that's great. And I think the answer is clearly not. So I do think that one of the important things we need to think about is, what is it that we're after here? And I don't think it's limiting corporations as corporations. One of the things Scalia points out in his dissent, or not in his dissent, in his concurrence, and that is in the majority opinion, is that the vast majority of corporations in the United States are very small, and many of them are nonprofits, and they're nonprofits on the left and right. I mean, the Sierra Club and the Children's Defense Fund and all these kinds of organizations are corporations, and they should have a role in political debate and political discussion in this society. And the idea that merely because they're a corporation, they should not, really seems weird to me. I mean, if you want to argue,
it's absurd. It's absurd. I mean, and then what would be the alternative? I mean, what do these people? First of all, it's great that you point out that the case wasn't even about corporate personhood, because it's such a distraction. If people want to eliminate corporate personhood, they might try filing a lawsuit where they make that challenge. That was not the case in Citizens United. And what do people think will happen to all these organizations that are now operating in the corporate form if their constitutional rights are taken away? They're not going to just go away. They still have to operate. So I think, go ahead. I'm sorry.
Oh, I'm sorry to interrupt. It's, it even goes to the press. I mean, right? The press is all corporations, and Floyd Abrams, who's another great liberal thinker and a man I would call at least a professional friend of mine, whom I like a lot. And he's pointed out to me that when he defended the New York Times in New York Times versus Sullivan, which is a landmark free speech case, he said, nobody ever suggested to him that, the Times shouldn't have rights because they're a corporation. That just wasn't anything people would remotely think about. Now, I know some people say, well, there's protection of the press, so that's separate, so the press would still be okay. First, I'm not sure we want that kind of press licensing system where if you're defined as owning a newspaper, you're okay. So if you're Jeff Bezos, a rich guy, and you buy the Washington Post, then you're okay, But beyond that, I think most scholars these days agree that the First Amendment protection of the press is not to protect people who are members of the press club or who have like the old front page newspaper movie, they have a little press card in their hat band. It's intended to protect the idea of publishing. And one of the great things about modern technology is anybody can publish. We can publish here using this forum on the web, and people can publish in blogs and all kinds of things like that. It's much more democratized. And that's what's protected, not people who happen to be members of sort of a club that's known as, quote, the press. So
that might be the most important point about this whole issue. I just wrote an op-ed in which I say there are so many reasons. I think you're making noise on your microphone. I just published an op-ed in which I say there are so many reasons why it's absurd and not even feasible to regulate independent spending, that the average person who's not familiar with all this can't even digest it all. There's just too much. And I've seen people suggest that maybe they should have just focused on the press issue in Citizens United, and that's enough to win the case. The press has been defined by the Supreme Court over and over again, not just in Citizens United and not just in cases related to election law. Over and over again, they've defined the press, as you just said, as an activity. It's when mass communication technology is used, and we're doing it right now. We're the press. So does it make your head explode that the people on the other side of the argument don't even address that obstacle?
Yes, it does. I mean, like you, I find the whole corporate personhood thing just a ridiculous abstraction, and it's entangled with that press notion. And again, the idea that some people, because they went to the Columbia School for Journalism, have our press, and they can say whatever they want about politics, backed up by the resources sometimes of huge corporations like the New York Times or the major networks, which are then in turn owned by big corporations like GE and so on, that they can speak and the rest of us can't, has always struck me as just something that is really not a tenable position to have.
Well, I want to go a little deeper on this with you, because the way you're talking about it now is it's just kind of absurd and so forth and so on. But I'm a layman and you are a legal expert. And I'm really curious what was in the minds of the people who argued the case. In other words, they surely must know, if I know it, they surely must know how the press has been defined. So why didn't they even address that issue? Because to me, it's just ridiculously self-defeating to say the press is exempt, but if everybody's exempt, what they want applies to nobody. Am I missing something, or is that not ridiculously self-defeating?
Well, that's an argument, and that's one of the things that scares people who believe in regulation in this area, is that, oh my gosh, if everybody's the press, then we can't have regulation anymore. But it's worth it for this. It might be interesting to viewers to understand the background of Citizens United. If you remember way back in 2004, those of us who are old enough to remember will recall that the filmmaker Michael Moore did a film called Fahrenheit 9/11, which was an attack on the Bush administration and its handling of both of events leading up to September 11th and after September 11th, and even accusing them of stealing the 2000 election. So it was a broad film. And Michael Moore said when he made the film that one of his goals was to see that George Bush was defeated in 2004. Right? That was why he made it. And of course, he made this using a corporation. It was a corporate enterprise. It was distributed by a corporation. It was produced by a corporation, and so on. And there were complaints that were filed with the FEC. I was on the FEC at the time, and we went through some contortions to dismiss those complaints, saying, look, this appears to be a for-profit endeavor, and look, we just were not going to censor a movie, right? I mean, we weren't that stupid. So we had to work a little bit, because the statute, if you just read the statute literally, would seem to have censored that movie. So along comes Citizens United, and they say, okay, we want to make a movie that's critical of John Kerry, the Democratic nominee that year. It's going to be kind of a rebuttal to Fahrenheit 9/11. And the FEC, they asked for an advisory opinion from the FEC, and the FEC said, well, we don't really think you're a filmmaker. Michael Moore, he's a professional filmmaker. He's an artist and all, but you guys, you're political hacks, so we don't think you get to make a film. So Citizens United said, okay, we'll show you. And they went out and they spent the next 4 years making a whole bunch of movies, little documentary movies. You think of something that gets the right wing all excited, they'd make a movie about it. We need to get out of the United Nations, or on immigration, or things like that, right? One after another. And these were documentaries, and one of them even won prizes at the Houston Film Festival in the best documentary category. And these weren't, most of them, though, the greatest documentaries, but they were movies, right? I'm not sure the FEC wants to sit as art critics, okay? Right. So then Citizens United comes back in 2008. They say, okay, so now you said, we weren't really filmmakers. We didn't have a history of making films. Now we've made, 10 films over the last 4 years. We enter them in film festivals. We show them in theaters. We do all these things filmmakers do. And we're going to make this movie. It's called Hillary the Movie. It's going to be critical of Hillary Clinton. Are you going to tell us we can't do it? And the FEC said, yes, we're going to tell you you can't do it. And that's what set off the case. And that should make people think about, what again is going on here? Are we going to say that the FEC is going to sit there as film critics and say, well, Michael Moore, I mean, he's a great filmmaker, Cannes Film Festival and so on, so he's okay. And you guys at Citizens United, your production qualities aren't as good, and you don't have as good a writers, so you can't make a movie that's intended to influence the results of an election, or it's a documentary on a political candidate.
Yeah, it's all about drawing lines, and people, the laymen don't want to have to deal with this minutia, but that is by definition what's required for this kind of regulation. And I'm surprised that more liberals don't agree just on basic fairness. I just got into a debate with a friend on Facebook yesterday who's in a band, and he was, taking the usual position. And I said, well, how would you feel about it if you went to make a CD and there was a song or two about topical issues that might influence an election, and you didn't even know, after all the effort of going into making the CD and releasing it, you didn't even know whether or not you might face imprisonment afterwards? Don't you think you should at least know? And I think that kind of moved him. So it's all about drawing lines and just basic fairness. But I want to press you a little bit more on this press thing, because it's been something I've been curious about for a long time. The back and forth between the FEC and Citizens United that you just summarized, I think most of that was before it went to the court. But I know you're not responsible for what the other side argued, but I really would like a little insight, if you don't mind giving to me, on what you think might have been in their heads. Because let me give you an analogy. Let's say the argument was, we're going to regulate speech, but not for everybody. It will not apply to males or females. Okay, now everybody would realize that even if they thought it was a good idea to regulate speech, that it's ridiculous to take that position because it would apply to nobody. Was it not just as ridiculous to say, okay, the press is exempt, but the press is everybody, and then not even go into court and not even have an argument about presenting a new concept of the press?
Well, I don't want to. I wasn't litigating the case for the other side, right? So I don't know, which was the FEC at the time, actually. And so I don't know what they were thinking. I mean, it amazes me that the FEC took the case at all, that they sought, enforcement rather than just acquiescing and saying to Citizens United, fine, show your movie. We're not going to prosecute you. But they did. And it shows how extreme, the law is here. The government came in, and the law, as you read it, covers movies, it covers books, it has an exemption for periodicals, which are like newspapers and magazines, and broadcast, news and public affairs broadcasting. And remember, the law came out, this law dates back to the 1970s. It does not, as some people think, go back 100 years and stuff, but it goes back to the 1970s. And the law, in the 1970s, you kind of could define the press, at least reasonably so. That is, it cost quite a bit of money to start a radio station or a TV station or a newspaper. It wasn't like today when, again, we have blogs, when we have cheap, discount printing if you want to do something in old tree print, when people can make movies on their home computers, really good ones, and distribute them cheaply by DVDs, when people can self-publish books and so on. So the law has this kind of, in the 1970s, you might have been able to get away with a law that says these people, the New York Times and the Washington Post and ABC and so on, are press, and the rest of you are not. I don't know why Americans would want to accept that as a matter of policy.
But why do you think they would be able to get away with it when the court has repeatedly ruled that we're all the press? How do you deal with that when it gets to the court?
Well, that wasn't really, in a sense, what the court totally hung on either, right? I mean, it wasn't the main argument of Citizens United. The court has, for whatever reason, held that it believes you can make that kind of distinction, or at least it had held that it believes you can make that kind of distinction in the days prior to Citizens United. But I think it really did fall apart when, nobody just thought about it much. And you get into the oral argument, and there at the oral argument, Justice Alito asked the government attorney, who was a very experienced attorney, a guy named Malcolm Stewart, Deputy Solicitor General. He had argued campaign finance cases before. He wasn't like a rookie up there, And Justice Alito says to him, well, look, using your logic, right, doesn't this apply to the internet? Doesn't this apply to movies that would be distributed over the internet, that sort of thing, or by satellite communication and so on? And Stewart knew then that he was in deep trouble because the government's position was, yes, it does apply to those things. That was their position. Their position was, we have an exception by statute for something called, quote, the press, but we don't have to have that exception. We've just done that because we're really nice guys, And eventually the government, Alito kept pressing him on this. And finally, Stewart said, yes, you could regulate the press as a matter of the Constitution. And at this point, this is when it all fell apart. And the Supreme Court jumped all over him. And in the final opinion, it essentially does strike at that very notion. It says, you can't prohibit, other people, other corporations, other individuals, other unions.
Yeah, I've seen that a lot of scholars believe that was the point where the case was lost, when the government lawyers said, hey, we can regulate books. And I listened to oral argument, which, by the way, I recommend anybody who's interested in this or any case should do, because you really get a much better sense of where the justices are coming from and what the various arguments are when you hear them argue it. And I remember very clearly, I forgot which one of the justices said it, but he said to the government lawyer, what if it's a 500-page book and there's just one sentence that says vote for so-and-so? Can you regulate it? And the government lawyer said yes. And then it was like, oh my God, because this is, it resonates on a visceral level, banning books because of one sentence. And so it was an unusual thing that then happened. The justices asked both sides to come back for a second oral argument. And then was it now Justice Kagan who argued for the government the second time?
Yes, she was Solicitor General and argued it herself. Yeah.
Right, and she tried to walk that back, the government's position that you can ban books. But I guess it was too little too late. The damage had been done.
And you notice she didn't totally walk it back. Her argument in that second argument was, well, we would never actually do that, which isn't quite the same thing. We don't have power to do it. It was kind of an administrative grace. Again, we're good guys. We wouldn't really go after books. And in fact, she made one assertion that the government had never pursued books. And that is kind of true in the sense that I don't believe that the FEC had ever filed a lawsuit seeking to prohibit a book. But the government had investigated the distribution of books at various times. For example, George Soros wrote a book in connection with the 2004 election, or maybe it was 2008, I don't recall. But the FEC did a very lengthy investigation into whether that constituted illegal campaign finance, contributions, and coordination, and so on. So, the government has gone there, and it had gone there in a number of similar circumstances. For example, there were early cases in which the FEC pursued actions against in-flight magazines like you get on the airlines, or the kinds of newsletters that you can pick up at a Walmart or a Costco or that they send to all their members, or investment newsletters. And this gets to the interesting thing too, what's a book and what's not. It's the early edition of the question, what's the press, right? What is the press? Is it the press? Is the Wall Street Journal the press when they give you financial news? But if I produce my, Bradley Smith investment newsletter, that's not the press. Those were essentially early cases like what we have today with the internet.
Yeah, it seems to me that the government got away with a lot of this by hearing my voice get back at me. That's so disconcerting. It seems to me that the government got away with a lot of this by just refusing to draw the lines and leaving people wondering. Because I think if they did actually draw the lines and people knew where those lines were, then they would just operate on the side of the line that's lawful. Like, for example, they were saying that commentaries, I think that was the word that was used, like what Rachel Maddow does and Bill O'Reilly are not subject to regulation, but political ads were. But it seems to me if you went to the trouble of defining that distinction, then the people who want to do ads would just alter the ads slightly so that they're commentaries. I mean, there's no reason why the people who want to give money to the networks and the networks wouldn't make a deal to just change the length of the commercial or the production element slightly. You follow what I'm saying?
Exactly. And, this is, it goes back to the point I kind of made earlier that for a long time, you could get away with this in part because it just didn't matter that much. The FEC used discretion. It didn't pursue people doing some of these things. If it did, like the newsletter cases, the in-flight magazine type cases, they were handled at a district court level. They didn't go up to the Supreme Court. And it's, we actually see this quite often in laws. I mean, if you pass a law and you never enforce it for a long time, it can stay on the books for a long time. But with the passage of the McCain-Feingold law in 2002, all of a sudden these laws begin to have a lot more bite. And this is what, it was provisions of that law that actually caught up Citizens United in their original case. So as the laws begin to have more bites, there are fewer alternatives. And, one of the things the reformers always want to cut back on is, the next loophole, right? There's some other loophole. So the law keeps ever expanding to cover more and more speech. And eventually when it does that, it has a lot of bite and somebody takes it to the court and we get back to first principles and we go, wait a minute, you can't do this. And that's really what Citizens United is. It's just saying, it says exactly, you can't define that, this handful of people are the press and the rest of these people are not the press. And this handful of people get to speak and this other group does not. And let the government have that power. And liberals who are enchanted by that should really pay attention to the advice of Ira Glasser and others who point out that, you can't guarantee who's going to be in charge of this stuff. The very first prosecution ever brought under the Federal Election Campaign Act was brought by the Nixon administration against a bunch of middle-class citizens who had taken out an ad in the New York Times urging that Nixon be impeached. And this was not for Watergate. This was before Watergate. They were urging his impeachment for the invasion of Cambodia. And the Nixon administration said, well, if somebody thinks we should be impeached, maybe they'd vote against us in the next election. And so they prosecuted these people as an illegal political committee. And I think, folks who are all gung-ho about this need to recognize you're playing with fire and you can't guarantee who's going to be in charge of this government apparatus that you're going to set free as a speech police.
Right. And that's a perfect example of what I had in mind before when I said there are so many different reasons why it's absurd, that there are too many reasons. People can't digest it all. And that's one of the best examples is why in the world would you rely on legislators? Why would you expect them to regulate in the way you want them to regulate? There's two issues. One is they may not have integrity, which is to say, usually people think members of Congress are scoundrels. So why would you think that they would regulate in the interest of leveling the playing field rather than in their own interest? You're literally giving them the authority to control how their challengers can spend money and run a campaign in opposition to them. So there's the issue of integrity, and there's also the issue of ability. I mean, why would you think with the when you say the playing field, it's like every media platform in existence, it's every form of communication. Why would you expect these people to have the ability to figure out how to level the playing field? It's just awesome. So I want to talk to you about UNPAC, which is a new committee/media organization that I'm launching. And the mission basically is to hold politicians, both candidates and office holders, accountable for their rather unlettered opposition to Citizens United. And basically, I don't want any particular candidate to win or lose, but I want any candidate to feel the pain when they start saying our fellow Americans should go to prison just for spending money on expressing an opinion. And we were talking about where to draw the lines and so forth, and it's still an issue. So I would like to talk about that, especially as it relates to what I'm doing, because it applies to not only me, but anybody that wants to do this sort of a thing. So I'm not a PAC, I'm not a media organization, I'm just a guy. So what can someone like me do, and what can't I do as far as if we want to escape regulation?
Let me give you a couple of examples of people who have gotten into trouble. At the Center for Competitive Politics, we defended a group called the Coalition for Secular Government, which was basically a handful of friends in Colorado who set up a website and they published papers that opposed what was called the Human Life Amendment. And for those not familiar with it, it's an amendment that seeks to define human life as beginning at conception and thus apply criminal penalties to abortions and so on, right? And they were very opposed to this, and they published these papers on a website. That was basically what they did. The state of Colorado, using state law, went after them for failing to register as a political committee. We also represented a guy in Ohio, where I'm based, named Ed Corsi, who, with some friends they used to get together and they'd have kind of like a study group. They'd sit around the basement or the living room and have a few drinks and talk about politics once a week or once a month or something like that. And they set up a website that basically Ed Corsi did by himself, and he called it the Geauga Constitution Council or something like that. And he criticized local office holders. And sometimes they would even print up a few flyers and they'd hand them out at the county fair or something. One of the office holders they criticized went after them saying, you can't do this. A Republican office holder went after them and used the state campaign finance laws. So, there's lots of people don't think this applies to ordinary citizens, but it does. And even if you don't want to do the things the Coalition for Secular Government did, or even if you don't want to do the things Ed Corsi did, don't you want to hear their voices? Don't you think they should be able to do those kinds of things? I think the answer is yes. Now, at the federal level, the FEC has, and they've been very criticized for this, by the way, but they've given a very, very broad exemption that they've written in for nonprofit activities on the internet. That is, if you pay to put an ad on a site, you're regulated. But basically, if you just have a site of your own, you spend money for it, whether it's a blog or whether you're using a platform like this, if you're doing those sorts of things, the FEC gives you a pass. But if we were to go, if you were to take your operation sort of off the internet, if you decided that it would be more useful to do some traditional radio ads or something like that, then you would probably be required to register as a PAC, or at a minimum to file reports as a non-PAC spender in a race and identify who your donors are and your contributors, and you'd have to have meet various regulations about how you handled your money and so on. And most of this stuff gets quite complex. Again, people don't think of how hard it is, but a professor at Missouri named Jeffrey Milo did a study where he actually paid people to try to complete the basic forms that you would need to file with the FEC. And he paid them. So they had a real incentive to get it right. They got more money if they got it right. And nobody, literally not a single person in the group was able to complete the papers correctly. And the people got really mad at it. They were frustrated. They're like, this is terrible. Why are you making me do this? People don't realize this because most of us don't do this activity, right? But it's just like most of us don't, we don't water ski, or most of us don't, go to dog shows, but we think that people should have a right to do that. And someday we might want to, and that's what would happen. Someday you might want to be engaged in politics. Someday there might be a local, race or issue that you want to be involved in. So, you've got a pretty broad exemption here on the internet, but we go off this internet and it's regulation city.
Okay, well, I'm glad that I have an exemption. You mentioned a couple of minutes ago if it's done in a non-profit way. Can you clarify what that means? Because I want to take donations and use that money to make videos. Is that kosher?
Well, this is not legal advice here, all right? In this kind of forum.
This whole thing is about me coming up with a way to get free legal advice. I do it in an interview forum. Anytime I need legal advice, I call a lawyer and say, hey, let's do an interview.
Yeah, you can have a site that is supported by, political donations, and there may be tax ramifications one way or another on that. But again, you're within the internet, and you're probably going to be okay. Where you get in trouble is if you pay to carry your content on other sites. In other words, if you pay to advertise on somebody else's website or something, then you could be drawn into the regulatory web.
Okay, so that might answer a question that's been gnawing at me for a while, not related to me, but just in general. I really haven't seen anybody address this. There's a lot of talk about PACs and super PACs and so forth, but I haven't really seen hardly anything on why are they forming PACs. In other words, what is motivating the people who do it to form a PAC? And so is it because they're required to, because of their activity?
Yeah, let's do some history here. That's pretty simple, right? The Federal Election Campaign Act of 1974, amendments to the act that were passed in 1974, for the first time limited the ability of individuals to give money to political campaigns. Realize that before that, a lot of people think, oh, you have to limit this. Most of American history, we had no limits whatsoever on what an individual could give to a political campaign. And people gave millions in today's dollars straight directly to the candidate campaigns. Okay, this was prohibited by the law. In a case called Buckley v. Vallejo in 1976, the Supreme Court upheld these kinds of limits on direct contributions to candidates on the grounds that they could appear to be like quasi-bribes, they could be corrupting of candidates and so on. But the court also said you cannot limit what people go out and spend on their own. If they just want to go out and spend their own money on an election, without giving it to the candidate, there's no bribery there. Sure, the candidate might be grateful to them, but there's no guarantee the candidate will, and there's not that opportunity for sort of a quid pro quo trade. I will give you this if you agree to do X. So this was the basic core of Buckley v. Vallejo. The FEC interpreted that, though, and I think wrongly, but for many years, again, did so, as saying, okay, so contributions can be limited. And thus, if you contribute to somebody who's spending money independently of a candidate, it's a contribution, therefore it can be limited, rather than thinking of it as another way of making an expenditure. So to illustrate that, if David Koch goes out and spends $1 million, that's perfectly legal. And if Charles Koch goes out and spends $1 million, that's perfectly legal. But if the two of them get together and pool their resources to spend $2 million, then that would be illegal. Neither one could contribute more than $5,000 to the effort, was the way the FEC interpreted the law. Mm-hmm. And you could substitute other names if you want. You could take, the late Peter Lewis and George Soros. Each of them could spend $1 million. But if they said, let's coordinate our activity, let's put it all in one pot, so we're not duplicating one another, and we get some efficiencies of scale, then it would be illegal. They could each do only $5,000, right? This is basically something that is challenged in a case that the Center for Competitive Politics brought, called SpeechNow.org versus FEC, which was decided about just 6 weeks or so after Citizens United, and for many people is lost in the shuffle. But really, SpeechNow is the case that actually established super PACs, and what it says is people can pool their resources, give it to a PAC that can spend as much as it wants on political activity. Now, why do people do that? Because they can't give it directly to the candidate's campaign. There's a lot of people who might say,
I understand that, but why don't they do it some other way, like not even form a PAC, like in other words, like what I'm doing?
Well, if you do it as a for-profit corporation, right, then you got to pay taxes on the gifts people give you to fund it, right? If you do it as a nonprofit, something like the Sierra Club or the NAACP or Planned Parenthood or anything like that, then you're very limited in how much political work you can do under the tax code. And if you want to go off the internet, then you can't do it. Again, you get this big internet exception, but if you want to do broadcast ads, if you want to do billboards, if you want to do get out the vote activity and so on, then you can't take advantage of the internet exception.
That's what I don't understand. It seems to conflict with Citizens United. I thought the Citizens United ruling was if it's done independently, we won't regulate it. But you're saying if it's done off the internet, what is it that triggers the regulation as opposed to just operating like a media organization?
What Citizens United says is you have the right to spend as much of your own money as you want, right? Mm-hmm. But you still actually are a PAC, which means you still have to register with the federal government. You have to file regular reports with the FEC. One of the things that's interesting, you can't even quit unless the FEC gives you permission, right? So people form these super PACs. Sometimes people talk about them as being, unregulated. They're very highly regulated. The one thing they can do is spend as much money as they want, and they can take contributions from any source in any amount to make those expenditures. But they're very highly regulated organizations. But people.
Well, I don't want to go too much into the weeds. I'm sure there's tons of laws, and our audience isn't made up of all lawyers. But can you just say, in essence, what is it that triggers the requirement to operate like a PAC as opposed to a media organization? In other words, Fox News and MSNBC spend money all the time influencing elections, but they're not required to comply with election laws. When are you required to comply with election laws, and when can you do what Fox News does?
There's an exception for the press. So anytime you want to go out and argue with the FEC and spend hundreds of thousands of dollars in litigation to argue that you're the press, you can do that. Remember that Citizens United does not do away with the basic idea that people can be regulated and that the press can get an exception. And nor does it say that everybody is the press. It's had other cases where the court has defined the press broadly. It says the press doesn't have any special rights. But Citizens United doesn't directly address that. And in fact, in the case that Citizens United in part overrules, Austin versus Michigan Chamber of Commerce, the Supreme Court held that you could have an exception for the press and that somehow you could identify it. So, the answer to your question is, let's say you have some friends and you want to go out and spend a bunch of money right? Say you have one guy who's got some pretty good bucks, and he contributes $40,000, and a few other people all contribute anywhere from $100 to $1,000, and you raise, 50, 60,000. You want to go out and do some radio ads, put up a couple of billboards or something, right? If you want to do that, you have to register with the federal government as a super PAC or as a PAC, which we colloquially call them super PACs, and you have to file all these papers with the federal government. But you can spend as much as you want, and you can spend it from any source in any amount. If you don't want to register like that, if you want to say no, we're press, right? Try that, but you're not going to get away with that because the FEC does not recognize things like billboards as a press exemption, and they do not recognize paid advertising on the radio as being within the press exemption. Only if you own the facilities, then you're okay. So if you can buy a radio station, you can use it as much as you want. But if you have to pay for a few hours of time, then you have to register as a PAC and do all
Okay, got it. Thank you. This is so illuminating and interesting to me.
Jeff, one thing here real quick, too, is the laws really are incredibly complex. People don't know this. And I remember when I was at the FEC, I met once with a group of Chinese who were here, and they were asking about the system. And I was trying to explain the law to them, and we were using an interpreter because they didn't speak English. And finally, the interpreter said to me, she said, I can't go any further. There are too many distinctions in the law. The law has separate provisions for electioneering communications and communications for the purpose of influencing an election and generic campaign activity. And it's got all these different names and terms. She says, I can't explain it to these people. I don't have enough words. And this is one of the problems with this law. Most Americans can't even begin to understand it. And I think that's one reason people don't trust the campaign finance system and often think it's much worse than it is.
Right. Okay. So you said you won't get away with it with the FEC, but what about with the court? And I'm sure the answer to that is, well, who knows? But what do you think? Has anybody tested that? What do you think the chances would be if this kind of situation we just discussed, and the FEC went after them and says you're not the press, and the organization or the individual said, well, yes, we are, and let's see what the courts say.
I don't think it'd be good. And I'll give you two examples. One is the case I mentioned earlier, Ed Corsi and his friends up in Ohio with their little study group, the Geauga Constitutional Council. And they tried to say that they were the press. They lost in front of the Ohio Supreme Court. And that's when they brought us in. Now, for what it's worth, I'm not sure that they litigated the case as well as one might have in the Ohio Supreme Court. But, we tried to appeal to the U.S. Supreme Court. The U.S. Supreme Court rejected the appeal. So that's one sort of example of where you can't win on the press exemption. Another and a bigger one would be a case that went to the Supreme Court. Again, this is the case that upheld the constitutionality of most of McCain-Feingold. It's called McConnell versus FEC. And there, one of the groups of plaintiffs in that case, led by Ron Paul, the libertarian former congressman, argued that they were press, that essentially the point you've made, that we should all be viewed as press whenever we engage in the press function. And the court there said, no, we think that Congress has the right to make those kinds of distinctions. And that just really, was not the basis. That was not directly overruled in Citizens United. So basically, you can go out, you can spend whatever you want, but you're going to have to, if you're doing anything that's other than what we think of as the press, if you're paying to put up billboards, if you're paying to send volunteers around, if you're doing things like that, then you're definitely not going to get the press exemption. If you're only doing things like, broadcasting and publishing newsletters and so on, my guess is you'll probably get it from the FEC, but you might have to fight for it. And that's essentially what Citizens United was when, like I said, they went out and said, of course we're filmmakers. We've been making films. And the FEC still said, no, you're not, and pursued an enforcement action or threatened to pursue one.
Okay.
Just want to make sense. Hearing at me like, holy cow, I can't believe this stuff.
No, I'm just going to jump out the window because no, I still think there's a way to do what I want to do. And you're saying as long as I operate on the internet, there's an exemption, but maybe not if I were to pay to be on another internet site. That's what you're saying?
Yeah, possibly not if you're paying money to other sites to advertise.
All right, so I can pay my cable company to have an internet connection.
Pay your cable company. You can pay your sort of volunteer expenses. I would think you could pay. If it costs you anything to be on a platform like this or something, a publicly available sort of platform, but you can't do paid advertising.
Okay, and what about doing an event, like a public event, to go into some venue and do a fundraiser?
Public events probably going to get you in trouble unless you want to try to claim that press exemption and argue that you're a functioning.
So I'm locked into an internet ghetto unless the Center for Competitive Politics will take me on as a client and fight.
That's right. Let's talk about that.
All right. Look, I'll make the fight if you and your fine organization.
I'll tell you, we are often looking for people who are willing to put it on the line to be plaintiffs. This is true not only in this area, this is true in a lot of areas. I mean, one way the government gets away with a lot of things that restrict our freedom is that it takes a lot of guts to be a plaintiff, right? You got to go out and essentially violate the law, right, and be willing to go through a lot in a lawsuit to try to vindicate your rights.
Well, would I face imprisonment or only fines for what we're talking about? No, I'm being serious.
We would probably try to arrange a lawsuit so that we would seek declaratory relief before you did something that could get you sent to prison.
All right. Well, in general, I have absolutely no fear about the financial implications if there are people behind me who have money. I would hesitate if I might face imprisonment.
Yeah, nobody wants to go to prison.
Right. All right. So let me just ask you one last question that's related to what I said, but it brings in other implications too. I'm curious. Do you think that Supreme Court oral arguments should be televised?
That's not an issue I've thought a lot about, and.
Well, let me just, the reason I ask is it goes back to what I said before about this perception of the court being, motivated by right-wing bias with regard to Citizens United. When I listened to the oral argument, it sounded to me like a bunch of ACLU lawyers with a very sincere commitment to free speech. And that might change some minds. People aren't going to click on and listen to the oral argument, but maybe if it were on TV, they'd watch it.
Yeah, that's a good point. I mean, I know the court's concern has been that would make arguments more flamboyant. It will reward those who, preen for the cameras and just change the dynamics of argument. So you may not get such a good argument as you get. I don't really know what the answer is to that.
Okay, well, I like flamboyancy. That gets people engaged. That's what's going on in this election season. Look how many people, whether you like or hate Donald Trump, look how many more people have been brought into the political process. Now, actually, that reminds me, you have something on, I think it's the center's Facebook page. One of the reasons, this is what a quote that I'm reading that was on your center's Facebook page. One of the reasons that Donald Trump has gained such a large free media advantage, laws that restrict paid media. What does that mean?
I don't recall the specifics of that, but one of the things that is worth pointing out here is that look at all the free media that Donald Trump gets, and he's had to spend very little money. In some ways, the only reason there's a race on the Republican side at all right now is because his competitors are able to spend money, and that the super PACs that are allied with the candidates are able to spend money. So that's a good example of a way in which paid advertising, in which money in politics actually equalizes political events rather than makes them less equal. People sometimes think it makes it very unequal, but essentially, if you didn't have paid advertising and paid spending, Donald Trump would be the nominee. By the way, Hillary Clinton would probably be the nominee for the Democrats. So
because it benefits the incumbent or anybody who has more name recognition if the other people can't spend money to introduce themselves to the public.
Exactly. And the people who then can get free media as well, which tends to be as well, the incumbents are people who have name recognition for the same reason.
So it looks like Donald Trump and Bernie Sanders, ironically, the way their campaigns are going, it sort of suggests that they don't have much of an argument when they say there's a need to regulate independent spending.
Yeah, well, Trump's funny because Trump has made this comment about how super PACs are so terrible. Which Republican candidate would benefit the most from the abolition of super PACs? It's Trump. There's no doubt about it because, again, he gets all the free media and all the free attention. And then he says some things that are just ridiculous. Like he says, well, I gave $2,500 to Hillary Clinton, so she had to come to my wedding. It's like, I would pay money to go to a Trump wedding. I think that sounds like a blast. The idea that, that she owes him something here is just absurd. But think about it. If you're Donald Trump, and he's held over the years a lot of positions that are not Republican orthodoxy, right? And his reputation is, I'm a tough guy, I'm a straight shooter, I know what needs to be done, which is kind of like, I don't waffle, right? So you don't want to go to Republican voters and say, well, I used to believe a lot of stuff that Democrats believe, but I don't believe that anymore. That's not a good argument for him. Much better is to just say, well, I had to do that because that's the game, and I was buying up these people, because I'm totally in control. That's the logical thing for him to say that's good. Oddly, Bernie,
I'm not sure the logic is part of the equation.
Well, Bernie, it works the other way around. I mean, Bernie, again, Hillary would probably win this if there was no spending. Now, Bernie's able to raise lots of money in small amounts, and hats off to him for that. But, he also has benefited in other ways. He rants about Citizens United being so awful. But when the founder of Ben & Jerry's, who made his money using the corporate form of Ben & Jerry's, goes out and introduces a whole ice cream line, Bernie's Yearning or whatever it's called, that's perfectly fine, apparently, to
right.
He doesn't.
Well, I think there's an important distinction to be made between Sanders and Trump, and I really think Sanders is the one who deserves to be condemned on this issue, because Trump, like any candidate, can just spew rhetoric in a campaign, and it doesn't necessarily have any consequences. Maybe it does, maybe it doesn't. But Bernie Sanders has gone way beyond spewing rhetoric. He sponsored an amendment calling for Congress to, again, be authorized to regulate spending. So that's where the consequences are a lot more severe. You might go to prison. So that's what Unpack, the effort that I'm launching, is going to concentrate on stuff like that, where there's real serious consequence. I think it's a moral issue as well as a legal issue if you don't think hard about what might send somebody to prison.
Yeah, I think you're very right, and people don't realize that. Again, there are big penalties attached to this, even short of prison. It's a big thing for people to be accused by their government of violating the law and doing things that are contrary to democracy. And they're sitting there thinking, all I did was spend some money, my own money, to try to elect or voice my own political views, and that's a big deal. And it's worth noting. I mean, people who are comfortable, the constitutional amendment, every Democratic senator in the Senate voted in favor of a constitutional amendment that would allow the government to impose, quote, reasonable restrictions on campaign finance and spending, including on corporations and all this kind of stuff, right? How many of those people would be willing to trust the government to impose reasonable spying on the American people with no regard for the Fourth, Fifth, and Sixth Amendments, or reasonable police searches on people, just determined by the legislature? I think most people, who are liberals, and I consider myself basically a libertarian, I think most people though would freak out, but they seem somehow happy to say to the government, we can impose reasonable restrictions on this kind of political speech. It's nonsense.
Yeah, well, it's emotionalism, and it's just a lack of critical thinking. They think they're so wonderful because they've identified a valid concern, which is, they want things to be fair and they don't want politics to be dominated by money. And they think that's the end of their responsibility as a citizen, to have that concern. And they never even enter the realm of evaluating this remedy or that remedy. And that's really what's motivating me to go forth with Unpack.
Yeah, and you're right. And people need to ask themselves, do I want to send my fellow citizens to jail for these kinds of activities?
I wouldn't. It's immoral. It's immoral not to think about. I mean, obviously, government is in the business of punishing people, but it's immoral not to be principled about, to not think very carefully about under what circumstances it should be done. And that's really what the core problem was before Citizens United, is that people didn't even know, and that should infuriate any fair-minded person.
Right.
So before I asked you about something that was on the Center's Facebook page, and I appreciate that you're not necessarily familiar with every single comment that somebody else might put up, but on your Facebook page, you posted this Johnny Depp movie that's getting widely circulated, where he does he plays the role of Donald Trump. And you said that if not for Citizens United, that might be an illegal video. Can you explain that? Because you wrote that, unless somebody took over your Facebook account.
Sure. And by the way, I'm negligent. I haven't mentioned this yet. If people want to look this stuff up, our page is campaignfreedom.org. Okay, so it's www.campaignfreedom.org, and you can find out a lot of stuff about this. The thing with the Johnny Depp movie, this is put out by the site Funny or Die, right? Is it's a corporation, and they used corporate resources to produce this. And if you take out Citizens United, the government could suppress this comedy movie. Now, they might argue, oh, well, it's the press exemption again. But again, one of the interesting things is if you just read the statute literally, it does not include movies. It very clearly, movies are not exempt from the campaign finance laws. And even if you said, well, the FEC wouldn't prosecute it as a movie, you'd be relying simply on the government's good graces and not on a constitutional right to produce that kind of movie. And I think most of us think you should have a constitutional right to produce a satire of Donald Trump.
Right. And recently, Jon Stewart waltzed onto Stephen Colbert shows. And you remember the two of them did over a period of months, if not years, I forget exactly how long, a spoof of the whole situation with PACs. And Jon Stewart walked on and gave a very direct pitch saying he wanted some legislation to aid first responders at 9/11 to be passed. I mean, it's the most blatant form of lobbying that you could imagine, using corporate dollars to get out a message. And I'm sure none of the people who scream about corporate dollars corrupting politics would have any beef with that.
Well, that's right. I'm not familiar with that particular episode, but that certainly occurs. They did a number of sketches about coordinating with super PACs and so on. And this is a gray area. People can disagree. They had advice of a very good campaign finance lawyer. But I will tell you, had I been on the FEC and somebody had brought a complaint about some of the things they did, I think they violated the law. That's what I think. And I've been a commissioner there.
Sorry, I missed that. Who violated the law?
That Colbert and Stewart did in some of their routines. Because remember, Colbert actually had a super PAC. And then Stewart was running it for a time while Colbert was actually literally a candidate. And I think they got away with it simply because they're famous and they're on TV and nobody wants to take them seriously.
Oh, I forgot that part. Colbert was a candidate, and that's what exposed them to possible criminal prosecution. That's what you're saying.
Right. You remember they had scenarios where they talked on the phone through their lawyer, and the question was, were they legally coordinating and so on. And
I remember all that, but I didn't, what office did Colbert run for? That's the part I don't remember.
President, wasn't? Didn't he run for president?
I don't know.
He won a primary, I think, in 2012.
That's outrageous. It's almost like Donald Trump running for president. What is they're making a mockery of this situation?
That's right. But again, I think they were able to get around it precisely for that reason. And what's pernicious about that is that people get the wrong idea. They don't realize these guys are able to do this stuff, which probably is illegal because they're stars and people don't take them seriously. But what if you're more serious folks? You can't do these kinds of things.
Right. So you would have said, you think they might have broken the law. You're interpreting the law, but you think that law is important and valid? Because I don't really see what the big deal is about coordinating, because most of these people who spend money, they know what the candidate wants anyway. So what are they going to, why does it change anything to say, hey, I want you to do this out a little bit that way? I can see it makes it enforceable. In other words,
it's a totally invalid law in my view, but obviously the Supreme Court has at least so far upheld those laws or not struck them down. The idea of coordination as turning an independent expenditure that you have a right to do into a contribution that you don't have a right to do.
Yeah. Okay. Well, Brad, thank you very much. This was a great conversation. As you said, your website is campaignforfreedom.org?
Just campaignfreedom.org.
Oh, I'm sorry, campaignfreedom.org. And mine is citizenjeff.com. If you want to check out the information on Unpack, just go to citizenjeff.com and click on Unpack, and you can make a donation. The restrictions you mentioned don't apply to the donors, right? They can donate as much as they want, right?
Right.
All right.
You've got to.
I just have to keep it kosher, but no restrictions, and they can be anonymous too, right?
I would think that they could. Again, this is not legal advice.
I'm throwing you curveballs there.
Getting what they pay for here, so I don't want somebody defending themselves saying, "Well, this guy," in a spur of a moment on the web broadcast said this, but should be able to do that. Yeah.
All right, we'll take that as an absolute confirmation and guarantee. Brad, thank you very much.
All right, thanks, Jeff.
Talk to you soon. Bye-bye.